And we will conclude our conference with the presentation of the last speaker, Deputy Chair of the Vice President of the Riga City Pardaugava Court and court perspective on working remotely. Hello everyone, I'm the first instance court judge responsible for criminal justice, and I will try to explain to you how we cope with remote work, what challenges we have encountered and how we overcame those challenges. Last year, from 13th of March to 14th of April, we were under the state of emergency declared by the Cabinet of Ministers, which was later extended until 9th of June, and currently we're again living in the state of emergency. The first declaration of the state of emergency determined that institutions should evaluate the possibility of providing the services that were previously provided in person in a remote setting. According to the labor law, remote work is the kind of work or the duties or the obligations or the responsibilities that are performed by a company employee outside the premises of the company or the organization with the use of ICT technologies. Remote work is only a way of working remotely from home in our case. So we were adjudicating the cases from home, not from the court building. And during the remote work period, we had to be available to the employer, had to comply with internal regulations and job requirements that did not go away because of the state of the emergency. We had all the technical devices before that already, so remote work was nothing new to us, really. We were already accustomed to that because it was introduced a while ago. So how did we manage, or how did we provide the remote work in courts? So you could have remote hearings, and you could also have out-of-court procedures remotely as well. Court hearings are the responsibility of the president of the court. However, just trial is an obligation that we need to comply with. According to the Constitution, everyone should be given an opportunity to defend their interests in a fair trial. And a fair trial can only be ensured if the courts are working openly, transparently, and efficiently in order to ensure the necessary precautionary measures with regard to the court proceedings. We had to evaluate and had to suggest, and still have to suggest, and offer the parties to take part in the hearings when residing in another country which is also heavily affected by COVID-19. And we should exclude by all means any appearance in person if possible, and should use remote technologies, should use the video conferencing for the hearings and proceedings, postpone the proceedings if somebody is on quarantine or has been affected or has contracted COVID-19. We should also ensure that the procedural sanctions are applied efficiently during the remote proceedings. So if you fail to appear in court because of the pandemic, you're not being punished or not being subjected to any procedural sanctions because of the failure to appear due to COVID. And we also had to arrange the work of our staff members and decide whether we take any requests in person. The president had to decide and arrange and tackle all of these issues. So in order to ensure remote work for the judges from their home, we have portable computers, laptops. We also have official email address that you can access remotely from outside the court. You can redirect the calls to your mobile phone, the calls that would normally go to your work phone. Such technical opportunities became very in demand during the COVID-19, and more judges are being supplied with the laptops, those who are willing to work remotely and have the necessary infrastructure. So last year, as we were hit by COVID-19, Cabinet of Ministers decided that the Supreme Court Chief Justice should determine the procedures and the requirements for the remote proceedings, proceedings that were already scheduled and proceedings taking place orally. Last March, Chief Justice issued an order that in order to decrease the potential health and safety risks for the parties involved in cases, only those proceedings that involve major infringement of the rights should be heard in person, and also decided to take the proceedings that are less serious or less important of the scheduled list. So we had to postpone a lot of criminal cases that didn't involve major infringement of any rights and were not didn't have to be fast-tracked, and Chief Justice also issued guidelines for the COVID-19 pandemic, and we had to contact the parties to the case in order to inform whether their proceeding is going to be delayed or will take place as foreseen, and we found out that they didn't have the communication tools to respond quickly, which basically decided the case with remote proceedings, and we primarily focused on video conferencing equipment. However, lack of access to the video conferencing equipment meant that if this case had to be tried immediately, we also had to have hearings in person from last March until December. No visitors were allowed apart from specific cases, because according to the procedural laws, you can accept the documents only in person in certain circumstances. Later on, this was amended.
We arranged the mailbox in our court where people could leave the documents, and the court staff also upgraded their skill, and they provided services very swiftly to them, observing all the security measures and sanitary rules. To control the flow of visitors, the court staff prepared lists of court participants in the cases, and these are given to the court guards, and only those persons who are expected, persons from these lists, could enter the court building, and they also had to confirm by signing that they had not been outside Latvia during the last fortnight, were not infected, and were not contact persons. The judges and court employees were recommended to work remotely if they have the possibility. So when we work remotely, we stay at homes, we limit our social contacts, but we also have to work full-time. And also the judge and the court employee should be accessible for communication, either via email or phone or video conferencing. We have in our court WhatsApp groups and also Teams conference meetings. That's a recent addition. Some practical aspects to work successfully remotely. You need remote access to your work email. Your phone has to be redirected so to ensure accessibility. The judges had to have access to court information system and the public, and also the shared documents of the court. And also the judges had to be able to use this secure digital signature from home. And the court had to provide also phone support to parties in the cases. So we really had someone to provide this service and also the court had to provide support for email communication. And we can accept documents via email if the client has signed by this digital signature. But of course, we know that not all parties in the cases have these technical possibilities and the signature. So the judges had to take these decisions on case-by-case basis, getting in touch with the person, and then somehow all these problems had to be resolved. And thus we ensured that in each case all the necessary problems were solved. And of course also postal services could be used. And that's why the physical presence of the judge in the courthouse is not always necessary. The judge can sign documents remotely, can receive all the information and the documents by using all means of communication and tools of communication. Now about hearing the cases during this emergency situation. Actually, we have to assess every day whether the incoming case is a priority case. To have a uniform case law in the court, we organized the judges' meetings and we discussed how the work would be organized, how the cases would be heard. And we also agreed that on the basis of legal acts and this declaration by the President of the Supreme Court, which would be the priority cases. Of course, the cases where the person has been detained, cases involving minors, and cases where we have to decide or change some medical coercive measure. And of course, we had cases with detained persons. And the situation actually evolved in the following way. The cabinet adopted this regulation or the decision that these persons were no longer convoyed to court hearings. So we had only video conferencing regime. And then it turned out that we do not have enough video conferencing equipment in the courts and also in the prisons. So we really, well, it was quite tense. We had to sort of organize these schedules, but we as the judges, we communicated among ourselves, and in order to use those premises with video equipment sufficiently. We understood that backlog of cases was developing, and a law was adopted now to introduce sort of legal order during pandemics, because now again we have emergency situation until the 6th of April, and the ministry on the 23rd of December issued new guidelines on how to organize work, and these guidelines define the cases which should be heard if it's in person. Those were, which are the priority cases, were very important. Rights have been violated where a person has been detained, and also cases involving official secrets. Actually, now we have become accustomed to all the sanitary measures, the mask, we are disinfecting everything in the courtroom. In addition to that, the president of the court really has to survey everything that's going on in the court. We should see to it that not too many people congregate in the court. That could create, again, epidemiological risks. So we have to coordinate the presence of visitors. Initially, we had to ask our visitors to obey by the rules, but now this has become a routine. In between these two emergency situations, the courts were offered some additional tools for remote hearings. We learned new technologies, and we continue doing this. Also, amendments were introduced to the criminal procedure law, stating that a person can participate in procedural activities irrespectively of the place where the person is, if the person has all the technical tools, and if the person in charge of the proceedings can verify the identity of the person. So actually, this has made criminal proceedings more effective, the course of this more effective. Before the second emergency situation, we already started using remote hearings in practice, which was very relevant in those cases where we had many participants in the case. Because we would need really huge courtrooms, and also some persons were abroad and could not otherwise participate in the case. And so we started also resolving those cases that were suspended during the first emergency situation. Later on, the cabinet, in its order, indicated that the courts primarily should use written proceedings or by remote proceedings, and in person only if the cases again involve violation of important rights and are objectively urgent, and that all sanitary measures must be complied with. And so the primary model is video conferencing. And of course, this virus entered prisons, and prisons went on quarantines. and also the accused persons fell ill, and we could not hear their cases. During the first emergency situation, it was rather difficult to organize video conferencing, but now in prisons also, things have improved. Microsoft Teams are used in prisons, but in Teams, because of security considerations, we cannot organize hearings in camera. And of course, persons may object to such remote hearings. And we have received such objections. Before the emergency situation, the criminal procedure law did not allow first instance courts to have many written proceedings, but amendments were introduced, and now also the first instance court is allowed to examine in written proceedings such cases which are linked to enforcement of sentences. So these amendments really alleviate the work of the courts, but not always. All the enforcements take place in accordance with this order, because those short-term detention sentences are not enforced during the emergency situation. And now in the law also provides that the cases which are reviewed as urgent and without verifying evidence can be examined in written proceedings. And also, if the case is heard remotely, the signature is replaced by confirmation, oral confirmation, which is also recorded. But of course, we should not forget about the person's rights to object against written proceedings, because the law provides for such possibility. And if the parties to the case object, then the case has to be transferred to oral proceedings. We have made some conclusions already. In the majority of cases where this written proceedings are proposed, are examined in written proceedings, but there are some persons who request oral hearing. Since the law does not demand reasoning to be provided, and so we don't know why the persons request it. It could be also an attempt to delay hearings. Then the court should offer remote hearing with remote participations. Persons who are not detained, we can use WebEx or Microsoft Teams. This is what we offer to the participants in the case. We have no problems with prosecutors. Prosecutors always agree to this. And they gain experience, which becomes very useful to them. For example, in Riga Central Prison, the quarantine went on for 2 months. And so the prosecutors also had to use those remote tools. Actually, the victims agree and also the witnesses agree, but the accused do not often agree to these remote hearings. The arguments they mention: lack of equipment, lack of skills, and also the accused want to have their defense lawyer physically nearby to receive advice at any moment. But currently, because of those epidemiological measures, people from 2 households cannot come closer to 2 meters. Another argument which is often used is that the right to defense will be violated because these remote consultations could be interrupted. Well, we have. But actually, we had offered them separate virtual rooms. If the court does not obtain the agreement by the parties to the case to remote hearings, then we have to suspend the case. If these cases are not objectively urgent, but we just suspend it. Perhaps this is a tradition or the belief that the true, genuine court And the hearing takes place only if the judges and all the parties are in one room. This could also be a wish to delay legal proceedings. Of course, it's easy and more convenient to organize court hearings in person, but these remote hearings, it's an opportunity for us. So we have those questions with remote hearing if a person is not in a place of detention. We have this tradition that we have detained persons in video conferencing, but now we also have to accept that we are hearing other cases also in this video format. And we also have those judges meetings in team. We discuss such court hearings. We encourage each other to go on, continue using it, continue experimenting. Well, the benefit is that the legal proceedings really go on. Communication is fast, and we also exchange information among us and also with the parties. But the disadvantages, judges belong to society, and when we work remotely, we lack communication. Also, we have some emotional problems with the situations that we have in the country, with the disease, with all the restrictions that we have. We feel concerned about the future, about future opportunities, and also about threats to our own health.
As to the technical drawbacks, some functionality might not be available. Technical arrangements might preclude you from carefully studying the case files as well, and protection, safety, and safeguarding the information from leaks are other concerns. But it is our responsibility because we need to ensure the non-disclosure of sensible information. Pandemic has taught us how to work remotely, use the technologies to our benefit. I am also personally very fond of remote proceedings or remote trials. First trials that we conducted in MS Teams were quite challenging because it was quite a steep learning curve, if you will. And I also had to go into the court hall with my phone because there was a connection broken down, disrupted, and you have to take into account that there may be electricity power blackouts, no broadband connection, and you have to just get used to it. You have to get over such minor hiccups, and you have to get used to remote working during the proceedings. And our knowledge might be also useful to other legal professionals. So we'll continue working remotely, and we'll continue our personal development despite what is happening around us. Thank you very much for your attention, and keep well. So if you have a question, you just need to unmute your microphone. You can ask the question directly to Gunta. Anything that you want. Again, we have the chat box as well for the questions, so you can use the chat box and Gunta will answer to the best of her ability.